he has given us the okay to go ahead. So I will ask the revisers, first of all, we have a new list. Do you mind going through with us the things that you have added, please?
All right. No, certainly we don't mind. Thank you, Madam Chair. Jason Thompson, Revisor's Office. I'll just recap each one and hopefully it'll ring a bell and we can skip over some if I got into detail before. So SB 30, that was on there before. That's the fingerprinting background check. SB sub for SB 54. That one's new to this chart. This is one we talked about this morning that we were waiting on Senate action. They non-concurred, and so now we're awaiting House action to accede and place it in conference officially. This one limits discovery and disclosure of third-party litigation funding agreements, requires reporting of agreements to courts. You can see the main difference is just that the House removed all the provisions that would have required the Judicial Council to study these agreements and make a report to the legislature and others. So you're the same on everything except that Judicial Council piece that was removed. SB 84, that's the financial crimes or financial card crimes involving gift cards. We talked about that one this morning. 135, child-related orders under the Protection from Abuse Act. We talked about that one this morning. 156, unlawful use of a laser pointer. Talked about that this morning. 186, this one will be new, I think. No, we're still waiting on House action on this one. So, yeah, so we did talk about that one, but we're still waiting the House to officially take action to accede to the Senate's non-concurrence. I don't know that I actually recapped that one.
I don't think you did.
That might actually be new. Yeah, okay. Now that I'm looking at it again, this is the one that spills over onto 2 pages because there's so much new in the House version. So, so as the Senate passed it, this had one section, 186. 186 is, so section 1 in the Senate version was just requiring the affidavits or sworn testimony in support of probable cause to be made available to law enforcement agencies prior to execution of a warrant or summons. This was kind of about the new case management system, court record system, and making sure those pieces of information were given to law enforcement. That section is retained in the House version, but it's section 2. So let's cover the other things. The House added section 1, which was the contents of House Bill 2401. That is an amendment to provide that prior convictions of a crime that has been determined unconstitutional shall not be used for criminal history scoring purposes, which is current law. And then the new exception, unless the basis of the determination of unconstitutionality is later overruled or reversed. So the House heard this bill. It's a fairly in the weeds criminal sentencing issue. We can talk about it more if the Senate has questions, but that's the bill that was put in there. Then section 3 is also new to the bill. This is the contents of House Bill 2389, which the Senate had a version of, but I don't think heard, if I recall. Anyway, this is the piece related to defendants charged with certain sex offenses and setting their bond conditions. So the House version of the bill has that if the defendant is charged with one of those crimes I listed there, the magistrate determines prior convictions of such offenses or comparable out-of-state convictions based upon available evidence. If the magistrate determines you have a prior conviction of any sexually violent crime, as defined in the Offender Registration Act, then your bond shall be at least $750,000 cash or surety, and you have minimum conditions of no contact with victims or witnesses, and you're placed under a house arrest program. All of those conditions apply to you. Further, bond is not reduced or modified unless the magistrate makes a determination by preponderance of the evidence that you are not a public safety risk and you're not a flight risk, and there's a presumption that you are both a safety risk and a flight risk that has to be overcome. Finally, the section 4 is related to that. It just updates a cross-reference. So that is Senate Bill 186 with 2 new additions. And I put those in the wrong order. I apologize. I was trying to sort, and I put 186 above 157. So there you go. We'll move those on version 4, which will be coming after we get some more action by the House and Senate to fill out the rest of the chart. So I'll fix that error. 157 we did talk about this morning. We're awaiting the House action. All right. Now back in order on page 6, Senate Bill 204. This is the case and warrant information sealed in criminal and juvenile offender cases. I think this one's new. The Senate non-concurred recently. As it left the Senate, you can see we were sealing records upon filing in criminal or juvenile offender cases in which arrest warrants are being sought. The House accepted passed the same bill, except the amendments removed subpoenas from the seal definition and instead added a sentence that says subpoenas and returns of service for subpoenas shall not be made available to the public. So they're not sealed and completely unavailable, but they are not available to the public. So a different approach to the same sort of issue, I suppose. Senate Bill 237 then. This one is also new to the chart for this round. This requires the court to consider the value of retirement accounts if a person loses income for certain reasons and eliminates the exemption of pension and retirement monies from claims to fulfill child support obligations. The Senate passed over a bill with 3 sections in it, doing what I just talked about with child support and retirement accounts. The House essentially just removed one section, the one that talked about material change in circumstance and modification of child support orders. That was removed by the Senate, by the House as a floor amendment, as I recall. So, but otherwise, the content is the same. And that is it for the Senate bills. I'll turn it over to Natalie for the House bills.
Madam Chair, do you have questions?
Are there any questions first about the Senate bills? Senator Warren, or
Yes.
Chair Warren?
Thank you. Regarding Senate Bill 204, what was the reason to remove subpoenas from being made available to the public and the return of service?
Yep. So, maybe Jason would want to elaborate, but my recollection is OJA had they wanted a little tweak to that. And so it really just kind of changed it where it was in the sentence. And they also wanted the return of service to make sure, the law enforcement wanted also return of service to be in that same, they wanted it to be sealed from the public because returns of service has personal information on it. And so they wanted to make sure that that part was sealed. And then the subpoenas piece, we just kind of changed the order, put it in later in the paragraph. Would that be an adequate explanation?
Madam Chair, yes, I think that's adequate. If you want, I would just say, you're correct. Law enforcement was concerned about adding the returns of service. So that was kind of one aspect of it. And OJA, or the court more broadly, was concerned with if you seal those subpoenas and returns of service, it does one thing in the court computer system versus if you make it not available to the public, it does another. And to give law enforcement access, they suggested it was better to make it not available to the public rather than sealed to accomplish law enforcement's goal of seeing it, but the public not seeing it. That's what I remember.
Thank you. With a follow-up question, so the warrants will be available to the public once the warrant is executed, but the subpoenas and returns of service for the subpoenas will not. Do I have that right? Because warrants contain personal identifying information and addresses too, so I'm just wondering why they aren't treated the same.
Okay, hold just for a second. Okay, so if I remember, isn't this about ahead of time? They need that information ahead of, beforehand.
Right, I think we're talking about disclosure once the subpoena has been served, once the warrant has been executed. So correct that neither of them currently would be available to the public before service or execution of them.
Yes.
So, but I'm talking about after service of the subpoena and return of service and the warrant information.
I'm going to try, I'm just going to try and see if this explains it. So before the warrant is executed, right now, the law enforcement is being treated as the general public. So so then they needed that information ahead of time, right? So then that's what the bill was mostly about, but then and then we added the other piece because of, they wanted to make sure the return of service was not public. And then the court system asked us to change the way that we handled the subpoenas. But I don't think that answered your question, so maybe.
Also, in section 1 where this amendment is, it's talking about before the subpoena is served, but then is it also then talking about after the subpoena is served, I guess is my question. What happens after the subpoena is served? Then is it made available to the public?
Okay. There's two competing pieces here, right? So I'll walk through the warrants one just because it makes the most sense to me. With the warrants, they're sealed until executed or the request for warrant is denied. And then there's a criminal procedure provision that kicks in for warrants and getting access to search warrant information, that sort of thing, right? But this is an arrest warrant, so it's treated differently, and that's why it's here, I suppose. The subpoenas, it says they are sealed and only unsealed if the court makes a finding that unsealing such subpoena is in the interest of justice. And then the paragraph that's defining seal is where the change is. So seal means no information related to a case or warrant, including its existence, is made available to the public. And then the sentence is added that subpoenas and returns of service for subpoenas shall not be made available to the public. So it's kind of the way you're defining seal for the case and the warrant. It means no information is made available to the public. For subpoenas and returns of service, those are not made available, but not in the same way. And they can, under paragraph 2, be unsealed by a finding that it's in the interest of justice. I know it's a little convoluted. Sorry, I'm trying.
Okay, thank you. And when you say under paragraph 2, you mean paragraph 2 on page 1 at line 14?
Right, it's subsection A2. So there's A1, 2, 3, 4, and 5 are all kind of new language there on page 1. Yeah, so line 14 is paragraph 2. Yeah.
And the bill only talks about in juvenile cases, or actually it talks about all cases? No, it's just about juvenile cases. Criminal or juvenile, okay, I recall. Okay, thank you.
Hello, Senator, welcome. Okay, yeah, or do you have anything to add? Are we ready to move on? Okay. Okay. Revisers never say. Okay, yep, thank you. Natalie, one new House bill that we've added to our list. Thank you.
Thank you, Madam Chair. You've gone over the rest, we went over the rest of the House bills this morning, but this afternoon you added House Bill 2164. The way it came over to the Senate was a bill, it actually went through House Federal and State Affairs, but it would have authorized people who are 20 years old or older to apply for certification as a law enforcement officer. The Senate removed the contents of that bill, they substituted it and added the contents of Senate Bill 288, which as introduced was the same as the House version, House Bill 2404. New section 1 there would make it unlawful for any sex offender who's 18 years of age or older and whose underlying crime for which they're required to register was a crime against a victim who's under 18 years of age. Prohibit those folks from entering onto school property or attending school activity. Both of those terms are defined. On a first conviction, it would be a severity level 6 person felony. On a second, it'd be a severity level 5, and on a third or subsequent, a severity level 3 person felony. Section 2 amends 224901 just to include this new section in the act. Section 3 amends KSA 224902, the definition section, to include definitions of school activity, school property, and it also includes a definition of non-public school. That was a change that was made in the Senate committee to clarify what types of non-public schools are included. The House did non-concur, but you are awaiting Senate action, so this is one that's not technically all the way in conference. So.
Okay, thank you for all of those new adding to the list. Okay, so I think right now on the table, we just have House Bill 2062. And you asked for a little bit more time to look at that. And I mean, that's my understanding where we're at the moment.
Yeah, and just not ready to have a continued discussion on that bill yet.
Okay. Well, were there any Senate bills that you would like to bring up?
No, but I think we might be ready for House Bill 2134 if the House wanted to bring that up. That's regarding the Kansas Open Records Act and some changes there too. It's on page 8.
So could I ask the revisor, where are we at? Where are we with Senate Bill 70? That is also has some common language.
Sure. Thank you, Madam Chair. Senate Bill 70 was actually stricken from the calendar by Rule 1507, so it's dead.
What was 70? Oh, the other Cora. Okay. What was the vote count on that? I can look it up.
Madam Chair, it was 2614 in the Senate.
Well, okay, yep, go ahead. We can pass them out, I suppose. So we did hear Senate Bill 70 in the House Judiciary Committee, and we felt like since you had passed it out 26-14, that we should take that into consideration too, and the Cora language. Yeah, we took the language from 2134 and put it into Senate Bill 70. And then we made a couple other little tweaks to it too. So I don't have a suggestion for 2134 at the moment. because I feel like Senate Bill 70 is kind of still in play in our minds because the coma and Cora together. And so we, I think our preference would be to talk about how can we get those two back together. So I don't feel like we're ready with 2134 yet.
Sure, and that was our thought as well. Talk about Cora and Coma together and combine them two into kind of one bill that updates Cora and Coma and provides some transparency about how those processes work if you're a member of the public and making an Open Records Act request. I do think we might have some conceptual amendments to start considering.
I'll hand the floor to you then.
Okay, well, I'll hand it over to Senator Titus.
Thank you, Madam Chair. So what we had talked about was we liked generally the core language that you guys had, and I reviewed Senate Bill 70, and I think we would be interested in including, you had all of our coma stuff, and the changes you made were acceptable if you would accept the itemized list we added to 2134. I think adding that to what was Senate Bill 70 would get us at an agreeable spot.
Okay, just to be clear, so you know about the changes we made on Senate Bill 70 and you were okay with those changes?
So if I have them correctly, the two changes you made dealt with the obscene material based on the age verification, and then it was the technical difficulties for streaming, and then striking the 5-minute grace period. Yeah, we were okay with. Yep.
Okay, so I'd like to ask the revisor, what would the procedure be to mesh those two together?
Madam Chair, so the bill you have before you in conference is 2134. So you would take the sections from Senate Bill 70, all of them, except for the Cora charge section, which is what was, that's already in 2134. So you would take those other sections and add them to 2134.
And so I'd like to suggest that, I'd like to put that on the table for the Senate. I don't know if is there an amendment, is there a balloon amendment to visualize it, or we're just, it's kind of conceptual moment, conceptual. Okay, great. Which in conference committee, I'm good. Y'all probably know we don't do conceptual in regular committee, but okay, so I would lay something on the table for you to consider that we take House Bill 2134, we add the coma language that the House Judiciary Committee put in that, and the changes that we made in committee, and that we go with it as far as that language. So Senate Bill 70 inside House Bill 21, excluding the language, and instead putting the House's Cora language in. Yeah, please, go ahead.
Madam Chair, this might actually be easier to conceptualize. Jason and I were just, what the Senate's offer is Senate Bill 70 as
good.
it left your committee.
Perfect, as it left our committee.
Plus the itemized receipt language.
And we were good with that too, yeah. Yeah. Okay, so just House Bill 2134 passed the Senate 40-0, is that correct? Okay,
Yes, that's right.
okay, all right, there's a little typo.
March 19th.
Typo on our list. Okay, so since it's a Senate bill that we're taking the language of Senate Bill 70, who's making the offer? The Senator of the House? This one?
Right, it's a House bill we're working on, and then so the Senate offer would be to take the contents of Senate Bill 70 as it was amended by House Committee and put that into House Bill 2134. plus the
list.
Senate
Mhm.
amendment made to 2134.
Okay, and that's your
That's our offer.
offer. Okay, so let us chat for just 1 second. Okay, to confirm, the list that's added is just added language. Nothing was taken out, just added language. Okay, okay, we're great with that. That sounds good.
Okay, great. Thank you.
So I guess we got one thing done. Hooray. Okay.
Are you all in calendar at 4 o'clock? Well, do you want to suggest a time to meet, first recess of the second chamber tomorrow, or what are your thoughts?
Yeah, I'd love, or I'm assuming we're going in at 10. Do you have something earlier? Do you have something at 8? Anybody?
We have an 8:30 with House Commerce.
Okay. We could try for 9:30.
We could, that's not, we'll be caucusing at 9:30. And
okay.
I've got a bill to carry, so.
Whether or not.
Try 8 o'clock, but we can try. Yeah, how about first recess of the second chamber?
Okay.
Would be.
If there's no other, I mean, if that seems like, if we can nab that spot while we can, that would be great. If there, you know, if the 6 of us are not going to be on any other committees at that time, that sounds fine.
10:30, 11-ish.
Yes, we have something at noon. But 10:30 should be good. So it's upon the later recess of either the House or the Senate. And we'll just, please be in touch and tune in for the room. We're going to try to get a bigger
A warmer room.
A warmer room, a bigger room. And we'll see, but if everyone can just make sure you take a look at what the room number will be, but we'll make sure we get that done. Anything else? Any other questions or anything anybody has? Okay, then we'll see you tomorrow morning upon the last recess. Okay, thank you, everyone. We're adjourned.